All right, this is the judgment. The accused persons are facing 2 counts. The first one is the offense of forgery, contrary to section 351 of the Penal Code, and the particulars are on the 18th day, August 2011, at an unknown place and time within the Republic of Kenya, jointly with intent to deceive, forged a will of Esther Njeri Kamau, purporting to be genuine and a valid will, signed by the said Esther Njeri Kamau. The second count relates to the making of a false document, contrary to section 347D of the Penal Code, and the particulars are the same. You heard what the witness has said. I also heard what you said. I just go to my analysis. You'll get a copy and you'll deal with it. Now, according to the material before the court, there are 2 wills here playing out. The first will is dated 18th August 2011, and the other is dated 1st April 2009. While the first one, dated 18th August 2011, is at the center of the charges that the accused person's face, the other will is valid as it is not subject to dispute from the defense. Therefore, in respect to the will under contestation, the prosecution did not adduce direct evidence that the accused persons took pen and ink and forged or make it. Put differently, to mount the case against the accused persons, the investigators relied on indirect evidence and not the direct evidence. So the law regarding these 2 counts is set out in the case of Caroline Wanjiku versus the Republic, where Justice Mativo said forgery is the false making or material alteration of a writing, where the writing has the apparent ability to defraud and is of apparent legal efficacy with the intent to defraud. So 5 things here. There must be false making of a document. In other words, the person must have taken paper and ink and create a false document from the scratch. Number 2, material alteration. The person must have taken genuine document and changed it in some significant way. Number 3, ability to defraud. The document or writing has to look genuine enough to qualify as having ability to mislead others to think it is genuine. The other one is legal efficacy. The document or writing has to have some legal significance. And the last one is intended to defraud. So the specific state of the mind for forgery does not require intent to steal, but only intent to fool people. There are 2 reports which have been brought before the court. The forensic examiner's report, which is exhibit number 18 for the prosecution, and also another report by Emmanuel Kenga, which is defense exhibit number 1. But according to exhibit number 1 by the prosecution, exhibit 18, the examiner, upon analyzing the signatures on both questions documents, including the will dated 18th August 2011, and the known signatures, formed an opinion that they were not made by the same author. However, according to Catherine Wanjiru Aura, and according to her, she witnessed the deceased sign the will dated 18th August 2011. Additionally, a report by Emmanuel Kenga opines that the will dated 18th August 2011 was authored by the deceased one, Esther Njeri Kamau. Now, I note that both reports have analytical processes on how each arrived at the divergent conclusions. This, no doubt, is a glaring contradiction. This being the case, the guiding law on conflicting expert opinions is based on Same versus Bart and others, 1997, England. Jacob J., who observed that what really mattered in most cases were the reasons given for the expert's opinion, nothing that a well-constructed expert opinion containing evidence sets out both the opinion and the reasons for it. Additionally, it is tried law on expert evidence that a judge must not consider evidence in a vacuum. It should not be artificially separated from the rest of the evidence. To do so is a structural failing. A court's finding will often derive from an interaction of its views on the factual and expert evidence taken together. The more persuasive elements of the factual evidence will assist the court in forming its views on the expert testimony and vice versa. For example, expert evidence can provide a framework for the consideration of other evidence. Now, the fact that the will dated 1st April 2009, which equally distributed the properties of the deceased, has not been challenged, and which the prosecution stated to be the valid will as opposed to the one dated 18 August 2021, Section 111(1) of the Evidence Act comes into play. It provides that there is need now for evidentiary burden on the part of the accused persons to give a satisfactory reason of the possession of the will which is under dispute. How then did the accused persons come by the disputed will? Factual resume in this case point to the fact that the accused applied for the letter from Assistant Chief Isley. In fact, the relevant statute states that this letter ought to be issued by the chief and not the assistant chief. And they obtained death certificate in respect to the deceased without knowledge of other members of the family. It is clear that there was an intention to use two documents to perpetuate a scheme which was known with the rest of the members of the family. Though they allege that the will was read and they came to learn that they've been made administrators, that is being uneconomical with the truth. Otherwise, they could not have processed the death certificate and letter from the assistant chief. Eventually, there is a case before the High Court, which the complainants in this case are pursuing to annul the letter of the grant, which is in respect to the disputed will. Now, putting these things together, I am persuaded more that the will dated 18th August 2011 was forged, and the right will is the one dated the 1st of April 2009. In the end, I make a finding that the prosecution have proved their case beyond reasonable doubt, and I convict the accused persons under Section 215 of the CPC.
Him address you on the issues of sentencing.
Okay.
Since he's appearing before Justice Ombwayo physically in Nakuru.
Okay. All right, you can have it mentioned tomorrow, I think.
You know, I don't know.